Well, I would like to thank everyone who is here for being here. We're really excited, impressed, thankful that so many of you joined at such short notice. I think this is proof of it being a conversation that everybody is really eager to be having on multiple levels. Um, we decided to have this conversation just because we were hearing from many of you and seeing things on social and sort of feeling the buzz around about concern over most recently some changes in terms and conditions, specifically Meta and Adobe, also a little bit from Meredith. And so we're not here with like a giant load of answers so much as wanting to come together and take the temperature of the community and figure out where people's concerns are so that our efforts can be prioritized in a way that's focused and beneficial to all of you. This is a very, very nuanced, very changing landscape that has multiple sort of fronts to be tackled. And one of the things that seems really relevant, which we learned from the New York fashion workers work that we did, is that lobbying really works. So we're interested in finding and partnering with the right PR firms and lobbyists with this effort. And it's a national effort rather than a local state effort, given that these things really affect kind of everyone. So not that we want this to be a fundraising event, but that's going to be an expensive proposition. So we are going to look to you for support specifically for that, because the state lobbyists were expensive, but the national ones are going to be even more so. And it's a big conversation, and we can do a lot of work with other organizations. So we're reaching out and in the process of connecting with fellow trade organizations, some of whom are here, and we're happy to have you here. Also with lawyers, again, some of them are here. Doug from Cypress is here. I believe Emilie from Esther is here. And we're looking for other legal partners who have specific expertise in these areas and welcome ideas from all of you. But the main thing is to make sure we hear from you. So we know what's bothering us. We as a board talk about this all the time. And I think in little groups, you guys speak to each other. So whether it's raising your hand and speaking up now or putting it in the chat, or you can follow up later, but please tell us what is not only concerning, but also where you see bright spots and where you want to make sure we're not stepping into the wrong territory. Because as we've said from the beginning, whenever we talk about AI, it is a tool, and it is, for many of us, a very valuable tool, and we don't want to kill it. We just really want to make sure that in this specific sense, we're protecting the work of our artists, because that's where we see the biggest pitfalls and the biggest danger, because the companies doing this see profits and they see money there, and that's going to really, we're going to feel that the most. So the one thing we'll come back to over and over and over is, with that in mind, you have to register your images with that. You have to register your copyright, because at the very bottom line, that will help you. It isn't going to necessarily protect you against everything that's going to happen. But if you don't have your images or your illustrations or your artwork or your writing or whatever piece of creation you have registered, you have very little to stand on. I think I can let Kelly talk a little bit about some of these things, and then we'd love to hear from Emilie, from Doug, and from all of you with anything that feels pressing or exciting.
Thanks, Vanessa. I mean, like you said, we're not trying to kill AI, and we're trying to understand everyone's concerns. And I think that this conversation could quickly become a black hole of despair. So I encourage all of us to try to think through, what are our challenges, and how can the AMA as a trade organization take steps in the right direction to help guide this conversation? And with that said, I think we need to start with what OpenAI and other large language models say that they do. And what they say that they do is that they have gone out and they have learned, they have trained, they have used that training, and Doug, correct me if I'm wrong in all of this, but they have used that training to, when you prompt it for something, the machine itself is creating something new. And right now, the Copyright Office is saying you cannot get a copyright on that because no human hand was made that thing. It is something new. And that is also why they are saying that they're not infringing upon anyone's rights, because it's the learning that has allowed the machine to create something new.
Right. So currently, it is not a derivative work, and it is fair use. Is the way we understand it.
Yes. And there are challenges happening in the courts right now around that. The New York Times is one of the ones that's most noticeable, that when they put up a piece of an article compared to what is generated from OpenAI, it is very similar. There are other artists that have been challenging this as well. Some of those cases have been thrown out because those images did not have their copyrights registered. So Jen, maybe we can throw into the chat image partnership, which helps artists register their copyrights.
Image rights, not image partnership. Just
image partnership. Yes, thank you.
No, not image partnership. Image partnership is an agency. Image rights.
Image rights.
Image rights. Sorry. Thank you. So Emilie, do I have this understanding correctly of what you?
Respectfully, I wouldn't totally agree. I think that it's not definitive that, I'm sorry, I don't have great internet. I'm upstate. Apologies if that is unstable. But there's not a definitive answer that it is or is not fair use. There's not a holding to that degree. There's been some cases dismissed where courts have trended towards that. And that is certainly the argument that's at the forefront, mainly because OpenAI and Microsoft have very strong legal representation and are maintaining their arguments across the board in every sort of case that they can. And that's the position that they're taking, but it's not necessarily the position that the courts have held. And secondarily, with respect to the registration of works through the Copyright Office, it's true that for the most part, the works are not copyrightable because of the human aspect. However, a registrant can obtain registration of a works with that uses AI as a component, and it's not dispositive just because AI has been used, so long as they can show that it was made substantially by a human or with human input. So I don't think that there is a clear answer. I wouldn't say it is fair use or it isn't fair use, or it is copyrightable or isn't copyrightable, and I apologize for being so lawyerly about that. But what I think is important to note is the trends. I would say I would confirm with you that you're correct in that the trends are leading that way. But mainly just because those are the arguments that are being presented at the moment through the federal court system, and that we can get into the details should you wish, but that's generally where it's going.
Sure, it's definitely not as black and white as I describe, and I think that gray is what is brought all 100 of us onto this webinar, is what's happening in the gray that makes it so confusing for us all. And for us as a trade organization, trying to figure out where we concentrate our efforts in terms of lobbying, in terms of PR, in terms of challenging claims. And
I think also education, because, and Emilie and Doug, you can tell me if this is incorrect, but so many of us for many years have easily sort of given away this idea of internal use to clients. And I think that that's quite a vague, but previously kind of safe thing to give away. And we're now learning that can include, and it's such a gray area, that oftentimes if clients are developing their own LLMs, that's an internal use to them, and that they are allowing themselves that ability. And so we have to then be careful in our terms and conditions to clients that we specify whether we choose to allow that as part of internal use or not. My personal feeling is that that's I do not want to allow it because I foresee that while it's learning now, the trend of it, the future of it is going to be some sort of output for profit. Again, that's my feeling. If you're comfortable allowing that because you feel there's a value there, go for it. And I also think there is a potential value in the future to charging for that and to saying, okay, that's just a usage fee. If you want to be able to do that, you have to pay for it. It's just like you add it to the license. But
well,
it's
Jen,
part of what we all need to be aware of.
Sorry, Vanessa. I was just going to ask Jen to maybe throw into the chat to the language, the AI language that the AMA has recently put out as a suggestion to add to usage contracts that specifically limits machine learning on images. I know that my company has had great success getting this added to contracts, and I've heard from others that they also have been able to use this language in order to limit machine learning. Now, what happens when the images go over to the company, we can't always necessarily control, and it's hard to understand how some of these models work. But we have had clients, including tech clients, agree to adding this language to contracts.
And I think we do have some clients here. So if any of you are comfortable either now or in the future sharing some of the thinking behind either allowing or not allowing those terms in your estimates, we would welcome that insight. Not to put anybody on the spot.
Also,
okay, it can be a follow-up.
Yes. So
does anybody want to talk about something that feels pressing? Because, well, before that, if we do go back to the Adobe terms, they had said that they would provide some clarity today. Nothing's been released yet. In reading those terms very closely and with a couple of people, it doesn't seem as though, even if your images are cloud-based and even if your work is in their shared space, that they are taking your images, that they are scraping the images for output. They are also saying that they use that data for learning to make their tools more efficient. So again, it's a gray area, but I feel as though that immediate outrage that everybody had could maybe be put a little bit to rest, that they do seem to want to do the right thing. And I think everybody who was up in arms about it really got their attention. And we want to sort of piggyback on that type of visibility and outreach with this and with all of you to make sure that the concerns that we have are really listened to in that same way.
And that concern, that outrage is really important. Just to go back to what Vanessa said earlier about the Fashion Workers Act, we were 3 days away from that completely changing the way that we, at least in New York, do business. And we were all able to come together as a community. Thankfully, the AMA was already formed and had money in the coffers to bring on lobbyists and to help us fight that. And we got written out of that bill. So I say that because being outraged, using your voice, coming together as a community, we can affect change. And I think, case in point with Adobe, our broader community was very frustrated and they listened and they made some changes. Doug, have you had a chance to read what they've put out? Do you feel as positively as Vanessa does?
I've been watching it, and there are some things that make me feel better, and then but there are still a lot of things that are still scary about this. This remains to be still a brand new technology. Anytime you have a new technology that comes out, especially in connection with entertainment business, there is this existential fear and crisis. And there are a lot of questions that for a long time go unanswered. The legal system and the courts are notoriously slow. They are responsive rather than proactive in issues with respect to new technology. And I think it's going to be a while before we have definitive answers, in part because a lot of people still don't understand. We don't really understand what the technology actually does and what it's going to be used for.
Mhm.
Look, but I think that this is not the first time, right, that there's been a new technology that's come onto the market that's created some disruption and a lot of existential dread. I think what happens, what we've seen in the past, and and we're seeing now is, like Vanessa mentioned, gosh, we have to go back and think differently about how we have been drafting agreements and restrictions with respect to licensing, things that we thought were okay, like internal use. Maybe now, because there's a whole brand new technology that no one envisioned before, we have to sort of revisit. I think there's going to be, as Emilie mentioned, and I'm really excited to hear more from her on this because I know she's been following it closely. The legal challenges. To to me, this feels a little bit um, less of maybe a copyright question, because I don't know that I feel like that the main threat is that we're going to come in and have these companies come in and ingest all of your artist's data to then copy or be something substantially similar to a work that your artist has already put out there, which is really what copyright is intended to protect against, as much as it's just going in and gobbling all of this information and learning at such a high rate that it's going to be able to create, quote unquote, original content that either has a sort of look and feel
Mhm.
of a particular artist, which is problematic, and that there are going to continue to be legal protections for, or it's just going to be able to go out there and create content that we traditionally thought that we needed, a whole creative team to do. I don't
Mhm.
know that that's going to uh, totally displace the market for creatives. I think there will always continue to be a place, and I think you'll have a lot of these companies that are in the AI business but aren't necessarily in the creative design business. And so what we're going to have to do is just be nimble. I think that there's a lot of anxiety around right now. People reflexively don't want their work and their images to be part of this experiment.
Mhm.
And I think that that's valid. And I think that there are going to be ways to try to limit that. Is already code that's available, that's out there for you to add to your own website to prevent companies from going in and just scraping stuff off of the internet. And I'm I feel positively about some of these statements about some of these big companies saying that they're not going to do that, but that doesn't mean that it's not happening, from an upstart. There is code that you can put on your website that's going to try to prevent that from happening. And I do think that we're going to see a lot more of these negotiations that are going to take place on the contract level that are going to try to uh, put some limitations, at least attempt to put some limitations on what a client can do with the work other than just publish it. Can they also feed it into their own LLM to try to make their business smarter?
So
And that's also going to be a lot of like market driven as far as what you're going to be able to negotiate with your clients.
right. One thing that brings to mind for me is this idea of claims, and I think this is a bright spot for us in for two reasons. I think one is that the FTC will be involved in a beneficial way because they're interested in preventing false claims, and I think the more work that is generated purely AI generated, the less ability that work has to actually make a claim about anything. It's not based on reality. You can't represent somebody who's actually doing something or have had a benefit of something in the beauty world. And so there's an angle there that I think is useful for us to consider and look at to benefit us in the work that we typically do. And then that also potentially protects the ability of all artists to continue to work. And, whether we represent photographers, illustrators, or the people who work for them, we can keep those people in business through continuing to have a valid output because we can produce work that isn't false advertising, essentially. Um, and then there's this other sort of conversation happening around this made with AI tag that's being put on Instagram posts. And there's a not very helpful link on Meta to explain like when it has to happen and why it happens. And essentially, from what we can tell at this point, it is if your image has metadata attached to it that pretty much says it was, you retouched it in Photoshop because Adobe has this AI built into it, then therefore it was, to Emilie's point, partially made by AI, not maybe its whole thing. In fact, the posts I've seen were definitely not, they were just sort of generally retouched pictures. And I think that that in itself is a false claim or has the potential to be labeled that way. I mean, I don't want to get too far out of my lane, but I think being able to document those instances and keep records of that will be helpful for all of us as a community in the long run, at least for helping Meta to do those things in a much more transparent and accurate way. Because again, you can upload a screenshot of something that's completely made by AI and has no metadata, and then it's not going to get tagged. Whereas the one picture you just fix the blemish, then gets tagged. So there's a lot of evolving conversations around that that seem like we could be part of steering them in the right direction without a lot of legislation, just with some voices. So maybe, start doing those posts on Instagram as opposed to the copyright ones, which didn't really get very far. But we really do want to hear from you guys. So if somebody has, I mean, there's a lot going on in the chat, but we'd be happy to hear from any of you speaking.
I would think it's useful to also just think about it from the big picture, just like very, very pragmatically, that we're not, and OpenAI and the AI systems are not even arguing that there's no liability here. They're arguing that there's no liability for them, but that there is still potential liability for the person who's using their tools to create infringing works. And our firm was recently at a conference on AI and how it affects copyrights. And when we spoke with apologies, my exterminator, we spoke with the AI, the attorney, her name is Catherine, and she represents Microsoft and OpenAI. And it's really, their argument is actually very, very interesting. And without, if you're interested, I can give you a more legal analysis later, but to keep it very simple, essentially her argument is that the LLMs that are used are the same thing as a photocopy machine. Xerox machine is not liable for, it's interesting because they're not liable just because their device copies work exactly and can create infringing works. Not all of what they're creating is infringing works. What makes them infringing is the person using the tool. So they are liable. So interestingly, which may come back to sort of, circle back later in a way that because they're essentially shifting liability onto their users that they're also asking to use their platform and that's why Adobe put out those user guidelines immediately after releasing their updated terms. And it's not, I'm not as optimistic about them. I'm not like so cynical, but it's really, the reality is it's to be introduced later as evidence that they put out notice for the users not to use their platforms for infringing purposes. So then with the expected claims that are to come their way, they can say, we told them not to use it for infringement. We cannot be held liable for vicarious infringement because they themselves, are not creating the output, the person generating the work is. And I hope that that's clear. There's still potential for liability for the person who isn't using your work.
So Chelsea just wrote in the chat that Meta has launched an AI image generator tool that allows advertisers to upload existing assets, photography, art, into their LLMs. But that seems exactly like
correct.
So they shouldn't be doing.
Well, and that's part of their turn. So there's two separate, again, not to be too like legal about it, but there's two separate claims. Like one is the scraping and the storage that's done by the LLM and the AI systems. And one is the output that's created as a result. Like, is the output infringing of the work, and is the scraping and the storage infringement as well? And one is against OpenAI, and that's what largely these cases are about. And they're about dismissing those claims, and they're saying we cannot be secondarily liable. Go after the users who are using this tool improperly. And then there are the creators of the output. this is interesting because, and this, arguably they're going to also put out terms that say you have to ensure you have the right to use the images in this way, and they'll protect themselves in this way, I'm sure of it, and so they won't be liable. But and clients, just to be clear, when you are transferring a copyright or a license in perpetuity without specifically excluding AI, they arguably do have the right to use it in an AI generator. And if they do, what Chelsea is explaining is that they can upload an image that you or your artist has taken and ask to expand the background, for example, with imagery that's never been taken. It's not there, it's not real, but it adds to the effect of it in order to make it a banner or whatever it is they may need it to do. And that in and of itself is not infringement, and they have the right to modify the works. They have the right within their, so long as it's within the scope of their license, to do what they want to do with the images. It's whether, a bad actor is using the work without permission, or using your imagery without permission to create a substantially similar work. Is that, or is that not copyright infringement? It's sort of a different question. I hope that that's clear. And then just to make it more actionable for the AMA specifically, I think that there are two things that we've already touched upon that we can do, which is you or your artist should all be registering your works. The Copyright Office was also at this conference and noted a substantial uptick in copyright registrations as a result of these AI cases, because a lot of the cases have been dismissed because not all of the works are registered, and they need to be registered, and potentially timeliness will come into it, which I don't want to get into. But the important thing is just to say that you should encourage all of your artists to register their works. If you know of any system that registers en masse, they will invest in them now, because I think that now's the time, or we should all create one. And then the second thing that we can do is definitely amend the terms with the language the AMA has sent through in the chat, and ensure that AI language is explicit in your license terms, as well as your terms and conditions, that they are or are not allowed to use the work for training purposes. And those are the two actionable things that I would recommend doing just in the interim, since we don't have any definitive answers yet.
I think it's also really important that we try to educate around copyright. I mean, I think that we've seen the way in which work comes to a photo agency change over the last 5 years. And sometimes, a lot of times, it's coming in from production companies that have pre-negotiated contracts with brands or with advertisers where they have already bid out the job, and the copyright isn't taken into consideration. It's a limited time and limited use, or it's work for hire. And we do have one side of the image of the industry when it comes to live action, where for many years it has been the standard that it's work for hire. Granted, it became work for hire back in the 70s when there was only one form of output for moving image, and now that has changed. And when you think about all the media placements that are out there, it's kind of mind-boggling what all media now means. But that's something for us to have a conversation with our production partners, to help them understand why it's so important that they also try and help us include this AI language into the contracts. This is about our community as a whole being able to continue to create work on a volume that supports our jobs and doesn't make photography and even moving image a commodity. And that is something that we need to educate our clients on, as well as our production partners, because things have shifted and it's not the agents managing those conversations. I'm sorry, artist representatives managing the conversations the way in which they used to.
Totally.
And this largely affects artists are the kind of artists that you as agencies are representing are not, you're already negotiating usages. We just have to remember there's a whole wealth of imagery work artists that are giving over their copyrights that aren't, they don't have agents yet. And that these publishing companies and Adobe, Meta, Meredith, they have a whole wealth of intellectual property assets already. I mean, that's really what they're going upon, like rights that they have, not, it's probably unlikely to affect us if we're negotiating a license or our artists' work. It's really for the work that they have that's existing or any work that they own in the future. I think it would be very risky for them to use licensed work for AI generative purposes. So I think largely it wouldn't even affect us at this level anyways, just to be clear.
But I do think, I know a lot of us go and talk to schools, talk to younger artists. I mean, part of this is also a DEI issue, helping to explain what many younger artists don't even understand that copyright's a thing that they can even ask for that and to engage in the conversation. And engaging in the conversation is and giving them tools and understanding is going to be really important as a community, that education factor.
Travis and Juliet, do you guys have similar conversations with artists? And is there a similar concern?
You want me to take lead on this, Juliet? Hi, I'm Travis. I'm Executive Vice President of American Photographic Artists, and to be transparent, I'm on the Lightroom Advisory Board for Adobe. So there's that. I have been, I've worked closely with Adobe and certainly with AI, and I know a lot of people are very kind of. I think we're in this day of kind of fear and quick cancel culture, and the way things are advancing exponentially and even faster than the people that are creating AI are kind of. It surprises them. We're in a state where I think Adobe messed up. Bad PR, bad this. I think their intentions are good from whatever thing I've done with them as a photographer, being hired as a photographer, dealing with them in panels and everything like that. Their first and utmost question for years, and this isn't recent, for the last several years, I've worked with them for 4 or 5 years, was first is trying to create a community that is empathetic and sensitive and diverse, and they messed up, and they know they messed up, and nowadays you can't come out with a statement. Every little statement has to be perused, and just as you can see these updated terms, how messed up it got. I think people were misinformed on what certain things, there's, as we've kind of put here, there's many different levels to the usage terms. There's things being used in the cloud up and down, what that means, why they're changing those user terms, when and why and how they're using AI. They are not using it when you send it or do generative AI or doing those kind of things. They're not keeping your photos. But if you are subscribing to sell your stuff and their stock footage, you're agreeing to do it. But those are in the terms. They should be read. So there's different things. So everybody suddenly thought, oh, they're training all my work when I put it up there, which is not the truth. They pay for catalogs. They paid me quite a nice little amount for my photos, for many photos, to train their stuff. So I know they're being honest to photographers and training stuff. I won't speak for them. I can only speak to my experience with them. I think it is very important to keep them transparent and always keep them honest, and it's very important to have these conversations. And I've been trying to have a town hall and getting them together to speak with us in large, whether it be ASMP, APA, and AMA in a town hall. I don't know if that'll happen quickly, especially with now lawsuits introduced and pricing. They get hit with 3 things, within the last month, so they're going to be kind of slow to deliver, I think. My main fear is AI is out of the bag like Pandora's box, and whether Adobe's trying to do certain good things like content credentials, saying how much was used, what was used, and stuff like that. But Stable Diffusion is out there, and that can be a computer based on your home computer. So there is no restrictions. There's no oversight. So we have to educate and lay the groundwork of protections and let people know what it's all about, because it's not just the big companies. It's used in everything. And AI is now, like, you looked, who's the greatest stakeholders now? Google, Microsoft. AI is out there. It's going to be incorporated in every single thing we use. So that I heard a great thing that's like AI is going to replace us. No, it's going to replace everybody that's not using it. And it's, we need to figure it out. And this is the Wild West right now that we need to lay the groundwork, because if we don't lay the groundwork, it's going to pass us by.
Yeah.
So,
Well, I mean, I think it's great to hear your experience with Adobe, and I know that that's a company that the AMA wants to engage with, and perhaps we can come together through our trade organizations and have productive conversations. Because, like you said, there is a quick reaction that happens when statements are released, especially because, quite frankly, our communities are scared, and they're scared with reason. We've seen the opportunities for jobs go down. We've heard about clients training with internal LLMs, and all of those things are frightening without a clear conversation about why they're happening. Chelsea, I really love all of your comments in the chat. Thank you so much for all of your thoughts. And it is an interesting question. How ethically made? How can we identify that? And how can I actually think that is part of the conversation, that as a trade organization we can lobby and affect change on.
Because honestly, I mean, you're completely right, because none of these companies are going to do anything unless they're legally obliged to do, is the bottom line. And so we have to be part of that conversation to make sure that the regulations actually get written. Not only, I mean, it's going to be hard because they come with so much money, but I think the artist community can be very vocal and very strong, and we all have to come out and really be aligned on a certain set of standards that have to be upheld for our benefit. It's kind of simple. I mean, it's
right.
complicated.
I'm sure that the cases that are brought aren't dismissed on technicalities, like not having
Exactly.
registrations. Like that is what we can do, at least in our part. That's why it becomes so important.
And when I was reading the Sarah Silverman case and all the procedural issues that were lumped into that, which don't seem like it was copyright related, it seemed much more like the opinion of the judge just being like, nah, I don't think that's similar enough. And I think that's part of this culture of like us being vocal and making these people understand that like the similarities are nuanced, but it's jobs and like livelihoods are at stake for it. And so it can't just be like apples to apples, even though I think the Times one is a pretty good example of similarities, but didn't seem to go very far. But
no, this is a slight pivot, but I'm interested, Emilie, in knowing your perspective on this, because some of the artists that I represent and that I've been speaking to want to be proactive in terms of educating themselves and integrating AI into their work, and have conversations around creating their own LLMs that they can use their data, their photos to train. But they don't necessarily have the rights with model talent. They have concerns about how exactly that would work. I'm wondering what thoughts you have there for people to consider if they are looking to use their own resources to train their own AI tool.
I think that's great. And I really think that we'll see more of that, and artists should continue to do that. And with respect to third-party rights, it really depends on how the output is being used. For training purposes, I'm not aware of any rights that would be affected outside of the copyright because there's no public use. Talent rights are affiliated with rights of publicity and use of their image in a public setting, through advertising or editorials or whatever have you. And so if the output includes third-party talent rights, then they would just need additional permissions as any other. I don't think it would change that process at all, although I haven't seen how that affects things. I think that that's also important to register their works for those purposes as well, for sure. And with respect,
but not to play devil's advocate here, but isn't that exactly what the big LLMs are saying, that it's just learning and there's no output?
Yeah, I mean, to be clear, Well, there is no, with respect to the copyrights, they're assuming they're the copyright owners of their own work. There's no issue with that.
Right.
And assuming that the AI platforms or the Merediths and the Adobes of the world are the copyright owners of their work, there's no issue with that either.
Right. Okay.
And I
Good.
think that her question was with respect to third-party rights, like what the photographer should consider, the users, the copyright owners of the work. I think what really matters is as long as they own the work, like it's fine.
Okay.
Well, and but if they are, let's say right now it's just for comping, for treatment purposes, for reference, but at some point that were to pivot to be someone coming to them saying, hey, I'm looking for this image, say it's a stock request, and they use their LLM in order to create that asset that a brand would want to.
I mean, I think then the question is like, was there enough human input at that point for it to be copyrightable? Because the risk is like they're licensing a work that doesn't have protection, so it can be copied without sort of any penalty.
Right.
And that may not be advantageous to the brand to want to invest in.
Yeah.
But I would say that like legally, I don't, unless Doug, do you see any problems with them creating their own LLMs with their own archives?
Specifically, I'm thinking about talent. Like if let's say it's a lifestyle shooter that's ingesting talent. Like,
So talent rights are different from copyright rights, and as Emily mentioned, that what it's really trying to protect is a model's ability to use their name or more frequently their recognizable features to be able to promote some sort of commercial use. So that I think is what Emily was talking about, was it's really going to depend on what the output is. So if you're using this LLM to be able to create and the output is going to be a completely sort of unrecognizable talent or model in some sort of new image, then I think a model would have a hard time making an argument that use infringes upon their name and likeness, even if their name and likeness was used as a reference to create it. But conversely, you could have a totally opposite scenario where somebody's creating from scratch, right, or from images that and information that's been ingested into an LLM, a new work that's going to look strikingly similar like Brad Pitt. Right? And they're going to use that in an image that they never took a picture of Brad Pitt, but they were able to manipulate other images to look like him. Or they did take a picture of him years ago, but not in connection with marketing this whatever it is that looks like he's using or writing or enjoying in this AI generated image. That's where you're going to get into, I think, issues where, hey, look, you don't have the right to trade upon what I look like or my publicity or my name, and in order to be able to create the assumption of an association that I didn't give you.
Right.
So again, I think it goes to, it's less about using the technology, and that's what we're talking about a lot, right? These are, I think that the argument that Emily referenced that was being made by some of these technology companies is going to be persuasive, that these in some ways are like Xerox machines, or the big sort of seminal case, these are like VCRs, right, where you have this technology, and yes, it could be used to create some sort of infringing unfair work, but it also has some completely legitimate good faith basis for use as well. And that I think is going to be largely persuasive if they continue to keep it that way, to try to avoid liability for themselves and really put the onus back onto the question about how are these tools being used.
And I just want to add upon that, because that's a really good point, Doug. And one of the biggest arguments that the legal team at OpenAI was making, or Microsoft was making, is that largely the AI training purposes are for like larger public policy reasons that are significantly outweighed by like essentially like minuscule claims of copyright infringement. I mean, it doesn't mean That's not a legal basis for why there are no claims to be made, but it's a public policy one, and one that, is totally a lawyer move to sort of make, because their argument is that there are greater public policy concerns that they are addressing and solving, like healthcare issues and potentially new medications, and solves to a lot of ailments that is the main benefit of the AI LLMs and the platforms and the output. And that if in the process there are some copyright infringement claims, like, don't shut us down because of that. Largely, this is what AI is being used for. And that is another really essential component to their argument, which is, I think, going to hold a lot of weight, if not in the court of law, but certainly in the court of public opinion.
Well, I do think that one of our goals here is really to hear from you. So please, you can email Jen, you can email any of us. Give us, take a minute, whatever it is, but tell us where you feel our efforts are best placed, so that as we're amassing a plan, we're really listening to all of you. And we don't want to be in a situation where we have had an opportunity and missed it. And that really means you guys have to be vocal and you have to tell us what's important. And then, of course, we need you to donate to the cause. And if you have contacts, lobbyist PR contacts, any thoughts and ideas on partners we should approach, please share them, because the more we have in this conversation, I think the better. We have a couple of questions, or Lisa is asking a question. Works created by a team of photographer and art director, wardrobe stylist, a hair and makeup artist. Who copyrights these images?
The photographer.
It's a good question, because anybody who's contributing to the ultimate image arguably could have a claim that they have some copyright interest. That's why you see, and really you should be, if you're not using them, your photographers really, and production companies should have language in there to the art department and the stylists and everybody else, disclaiming any sort of copyright or any sort of ownership over the images. That's a really good question.
To be clear, the creator of an image is the default owner of the image unless there's a substantial contribution from a third party. So I think my answer would be definitely it's the photographer, unless there's any other written writing that transfers it to someone else.
Okay, there are a lot of people involved in the creation of it, not just the person that.
Of course.
No, of course, and I believe that they should have.
So by default, there kind of has to be that person at the top of the chart, of course,
exactly.
But
that's just a definition under the US
by law now that it's the photographer, right?
It is. It's just the U.S. Copyright Act that says that the creator of the work is the owner of the work the moment it's fixed in a tangible medium. So it doesn't even need to be registered for them to own the work. They automatically own the work, which is why the act, by the way, also requires assigned writing to transfer the work at any point, which is why you see work for hire language. Often and you'll see it as a default, as Doug mentioned, in agreements for stylists and hair and makeup, because they are transferring their rights should they have any. But the legal definition is the creator of the work is the automatic owner of the work.
Okay, thank you for answering that.
Yeah, no problem. I agree with you. They should have more rights and usage rights and renewal rights when the images are renewed. And it's too bad that those usage fees go to directors and photographers and not stylists, and prop stylists and hair and makeup.
In an image that we actually recently sold to another company, that photographer did take that licensing fee and distribute it proportionally among the rest of the team. Now I understand that that's the photographer's, prerogative to or to not do that. But I stand up for the stylists quite a bit.
Yeah, totally. We represent a lot of stylists too, and I think that that's a great standard. And Elle magazine actually pretty historically has paid for stylists reusage and renewal fees as well. So
awesome.
I have to give credit where credit is due.
Thank you.
We have a few more minutes before the hour is up, and we're so lucky to have Emilie and Doug. Is there any other questions?
I have just a quick question.
Yes.
This is Beth. A lot of the conversation, obviously, amongst artists that we represent in the community is what it will do to kind of the shrinking pie of work that we're all fighting for these days if agencies are creating the artwork for their ads internally. And what I've heard is that a lot of clients aren't using AI generated artwork because it isn't copyrightable, but obviously a lot is being used because I have clients telling me that they're creating work internally. So where are we with that at this point? I know that, the human touch, I mean, that was kind of defined early in the spring from congressional hearings as far as, getting a copyright, you have to have a human behind it. But obviously we're going to lobby to hopefully continue to have that be the case. But like, where are there parameters that with lobbying and laws, we can actually try to keep our pool of work sustainable?
I mean, I think right now that's a really good question. And I think it's up to individual clients, like knowing the work that can't be copyrighted, where they feel comfortable. Like if it's specific enough to their product or generic enough, and does it serve them better to spend very little money and get something that, somebody looks up for 20 seconds or 2 seconds, or whether they're considering that much more internal work, which is what I'm hearing more and more about, is like internal, whether that means a focus group or whatever it is, something that's not consumer facing, that's a newsletter, or, just pre-approval before a shoot or whatever the process is. But I think that's the conversation we want to be part of on a federal level, on a regulatory level. And that's where we need, to come together and figure out how to be involved in those conversations to make sure that is maintained. Or if it shifts in our favor, and we can help define what that shift might be.
I think there's a whole conversation around a lot of ad agencies as they begin to search for revenue are also creating their own production companies. And so we are not only bidding against other production companies, other artist reps, but we're now also bidding against the agencies, and they are having an opportunity to see our bids and our treatments, whereas we are not having an opportunity to see theirs.
True.
That is another conversation about just fairness in general in the industry, that again, the AMA, there's so many different priorities. We have to figure out where we're going to focus the money and focus the dollars. I think there is absolutely, we have to consider our community and maintaining our rights and maintaining opportunities. But I think that we also as a community, have to understand and recognize the change that's happening and figure out how we move with that tide and ride that wave the very best way that we can. And it's going to be complicated. I mean, I think right now, this is my personal belief, not an AMA belief, but I know others feel this way too. There's a lot going on. And so for us, it's finding that guiding light as an organization and as a community to push ourselves forward and create work within this. I personally believe that creativity is king, is going to be, as AI continues to grow and change and shape how we use these tools in a creative way, how we support our artists to learn, and how they're willing to adapt is going to be really huge and instrumental.
Well said.
Yeah, I also think that there is, Chelsea, you brought up blockchain. I think that is a very interesting thing for photographers to consider, because blockchain can also help us follow our images along as well. Oh. Thank you to
Anybody
everybody
else?
on. Yeah.
All right, well, we're going to send this out to those who didn't make it, but please continue to send us questions and concerns and ideas, and we will continue this conversation.
And we are going to be asking for people to consider helping us with this cause, because it's going to be a lengthy endeavor to have our voices be heard. So this is probably the first of many conversations around this topic.
I think that you should encourage Joe Naylor at the Image Rights Call to provide some sort of AMA like group registration rate, that if they're registered through the AMA, like we can get a preferred, because that's really the way that it's going to happen, is to have like a preferred, and he has a great platform to be able to register your works.
Joe is here, so Joe heard you.
Oh, great. Great. Joe knows I love his platform. I think it's really useful for artists and very easy to use. And hopefully there's a way we can make it accessible to everybody.
Yeah, thanks, Emily. I really appreciate that. So if you got a couple minutes, I did want to say a couple things. So everything Emily said on copyright with respect to AI, I totally 100% agree with. I think that there's two major separate issues. On the output, to me, the biggest problem is it can't be copyrighted, like we've been talking about. So what are you going to do with that? On the front end, the whole issue is around infringement with respect to training, but that cat's kind of out of the bag. The big models have already scraped, and so there's not a whole lot you can do there. But the kind of the biggest takeaway for me from the whole talk, which I thought was amazing, was that Microsoft is trying to do this analogy of the LLMs being like a Xerox copier, and they're trying to like put the onus on the user and frame them as the one that's going to take on liability for infringement. And what that's going to do is accelerate this push towards the use exclusively of ethical AI models, because nobody's going to want to take the risk of working and using things like Midjourney and Stability AI, those that are obviously and blatantly have infringed and have no qualms with the fact that they have. You're going to start seeing more and more from like Bria, Visual, some of these other AI companies that are doing ethical AI, getting everything licensed. I really liked seeing Adobe's response. Scott Belsky is a great guy. He came right out and was very clear. I thought their bullet point response on every issue was very well articulated. So it was good to see that. So yeah, and then the other thing that I thought was really cool was when Doug said that basically, there's, what was it exactly? So with generative AI, there's the copyright issue, and that's kind of a separate issue because the output of these AI models are not making copies of the original work. So that's not the issue. It's how the AI models are competing with photographers. So it's not a copyright issue, it's a competition issue. And at the end of the day, in my opinion, and from what I'm seeing, is that it still can't compete with true creatives. Like maybe it's going to take out stock photographers who shoot desks and offices, but if you really need to create something, that's just the tool. And so there was a guy from HH Global that was speaking at a DMLA webinar recently, and basically he was saying that all of their creative teams are using these AI tools. 80% of the workflow and in-process work, they use the tools for, but only like is less than 5% of the final product actually is AI generated. And frankly, that's largely because of the copyright issues. And so I think what you're seeing is all of these things are kind of coming together where it's truly, AI is really kind of showing its colors as a tool. And just like Adobe, to use Adobe since we've been talking about, they've been building all these tools for decades now to make artists' work more efficient, faster, and it lets them focus on the creative aspect rather than the tedious work aspect. And AI has been just such a jump that it's caused that much more consternation and fear amongst artists. And so I think as long as artists continue to create and understand how to use these tools to create, they're just going to get ahead. It's not something to run from or to hide from. The only thing that I truly think is a problem is that the Copyright Office won't recognize the output from AI as copyrightable work because there's no human authorship. And that's a tricky question. I'm not sure how to get around that, because you're not going to want to use output, at least commercially, if you can't copyright it, if you can't be
See, I
protected.
think that's a really interesting part of the conversation, because I want to be really careful personally that I don't disagree with you, but I think that if we're advocating for those images to be copyrightable, we're also stepping on our own toes a little bit. So it's a nuanced conversation. Like, I don't disagree with you, but I think that needs to be also defined well so that it doesn't create absolute competition for us and put us out of business.
Agreed.
Which is what I think the courts like align with, that there's not an answer that they have denied registrations because it hasn't been defined well, but it's not to say that they are going to deny all future registrations should the courts find a way to narrowly construe what is and what is not copyrightable. That's how anything, any realm of law that's developed through case law, it takes a lot of time. But I think what Doug said at the beginning is really true, that now's the time to really get involved, because we're truly creating a whole nother sector of the law. If there was an answer in the case law or in the statutes, it would be answered by now. So many people are asking so many questions, smart people, and they're not getting answers. And it's because it's not defined, and it is being defined now. So it is an imperative time to stay involved, to be involved. And in order to be involved, there are certain things we need to do, like keep our work registered, ensure that our terms are clear. And that way the right cases can be brought and the right decisions can be held. Because I don't know how much it's going to happen through statutes. Like, lobbying is really great, but it's really about maybe starting a legal fund. That way, when there is a case that's appropriate to define and answer these questions, we have a fund ready to support the firm to take that on.
I think
Does
it's
that mean we can also
PR too,
Yeah.
right? To make sure, because this is a whole new category of
Yeah.
art as well that has begun to emerge. So it's really about having our voices heard, not squashing it entirely, but helping to guide the conversation and to educate. And there's many different parties to be educated on this. So, both, like you said, Emilie, I think a legal fund is absolutely imperative so that we can be acting quickly, but also a PR initiative, which I know sometimes we all shy away from just the word PR, given some of our own personal experiences with PR people, but it is a way to have our concerns and our perspective heard.
Because I feel like there may be cases out there that, it feels very opaque to me. I don't know what's going on. Obviously, Emilie and Doug, you're more tapped into it, but how do we find out whether there's who can we tap into? Like, what conversations should we be having or being part of?
To be clear, there's not just this copyright infringement claims. It's interesting and it's relevant, but it's not the only thing that is ailing, that is a part of these claims. There's 1202 claims regarding credit, which I was going to answer to you individually, but removal of attribution, that's usually an additional claim. It's really not worth much. It's a max of 25,000 per claim. So it's usually an add-on claim. You can have an individual claim for it, but many people don't. But the courts have said that usually if in the most recent Tremblay case, that the courts dismissed the 1202B claim for lack of attribution because the AI system didn't credit Sarah Silverman as the author of the work when they regenerated the summary of her book, doesn't mean that was intentional. So they sort of dismissed that claim, although I don't think that's dispositive. I think that there are claims for credit. There are claims for breach of contract. That's what the terms, adding this language into the terms will provide. It's not going to create a copyright infringement claim for you, but it will create a breach of contract claim. So there are different ways to sort of approach this issue with the LLM systems and the creators or users or infringers, if for lack of a better word, as well as there's been claims brought for breach of terms of service and privacy policies that exist under Meta and Adobe for use of the work that has been pulled against the privacy that they owe to certain users. So there's a lot of lawyers getting really creative in how to bring these claims. It's not only copyright infringement and vicarious infringement, and those are other things to consider for how we can really not, keep it relevant.
Yeah. Okay, well, we'll start to again try to make some resources and information available, and we're always here if you want to email a question. Doesn't mean we're going to answer it right away, but we'll put it on the list. Thank you everyone for staying on and for joining us.
Thank you for having me to the AMA.
Thank you.
Thank you, Emilie. Thank you, Doug. Thank you, Joe.
Thank you.
Thank you, everyone.
Thank you.